And we are back here, Richard Nixon live, broadcasting live, streaming coast to coast on crntalk.com. That's crntalk.com. And Richard, can you tell us, I mean, your explanation of what an originalist is was very fascinating to me, but there's another point of view out there that some people take, more of the Constitution is a living, breathing document. Can you kind of compare and contrast the difference between originalist and a living, breathing constitutionalist? Because they're not really the same thing, and I think one more is factually correct than the other. Isn't that right?
Absolutely. In fact, there is no factual or legitimate basis for the idea that the Constitution is a living, breathing document. It's the supreme law of the land, and there's no, as I said, legitimate authority that says that the justices or any judge can, in a sense, rewrite the words of the Constitution or a statute. And in fact, I've got a short quote here that is ubiquitous in almost every court of appeals case, whether it be state or federal. And it basically outlines the function of a judicial officer, and I'll make it very brief. Our fundamental task in construing a statute is to ascertain the legislative intent so as to effectuate the purpose of the law. Now, so that says basically that a judge's role is passive, and that the judge's role is to simply effectuate the purpose of the law. That is what a judge is supposed to do. Find out what the legislature, specifically what the people wanted, and it's the judge's job to effectuate that purpose. Now, because the statutory language ordinarily is the most reliable indicator of legislative intent, we begin by examining the words of the statute, and we give those words their ordinary and usual meaning. Now, again, there's absolutely no room in that quote that I just gave for a judge to simply say, well, you know what, I don't like the word here, and I'm going to, if you don't mind, I'm just going to change a few of these. No, that's rewriting. That is not interpreting. And as we said earlier, Article 1 of the Constitution says that all legislative powers, not some, but all, reside in a Congress or in the Congress. And therefore, this whole idea of a living, breathing document was created by the Supreme Court to empower the Supreme Court and thereby disempower the people.
That's interesting because the Supreme Court that's actually a scary statement that you said, that the Supreme Court can empower itself.
Exactly.
And usurp the other two branches of government. How is that not checked under the Constitution itself?
Well, that's exactly right. And in fact, that is the genesis of the Marbury versus Madison case from 1803, where the Supreme Court actually held that the Supreme Court, had the authority to void an act of Congress, and they did so. And I won't go into a lot of details except to say that there were at least 3 or 4 bases for the Supreme Court at that time to dismiss the case out of hand. In other words, number one, there was the parties involved were actually related by blood to Chief Justice Marshall, who wrote the opinion.
Wait. Let me stop you right there.
Yeah.
The parties involved in this particular case were related to the Chief Justice seeing that case. How is that not a conflict of interest?
It clearly is. And further, under the Article 3, Section 2, Paragraph 2, the only way you can get into the Supreme Court by original jurisdiction is to have a case involving a consul or an ambassador or people such as that. This was not such a case, yet it was given original jurisdiction, which was a second flaw. Third, after Chief Justice Marshall dismissed the matter, which is the only thing you can do, I should say a judge can do when he realizes jurisdiction is improper, not only did he went further after dismissing the case to declare that he and the Supreme Court in general had the authority to to void any act of Congress, and did so. And if I have the time, I'm going to quote something from the 1803 case, Marbury versus Madison, by Chief Justice Marshall, who, by the way, is considered the most capable justice we've ever had in our history by both the left and the right. And I wonder why that's the case, given this very brief quote. He, Justice Marshall, writing for the court in 1803 in Marbury versus Madison, says, Now, he's talking about the legislature, but he says the powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten. The Constitution is written. Now, he makes it very clear that unless it's written, one might mistake or forget what it says. So he justifies that.
Absolutely fantastic. More with Richard Nixon right after the break. This is a fantastic subject, and it's so great to have a constitutional scholar in studio to talk about. We'll be right back on CRN Digital Talk. More with Richard Nixon live. And we are back here, Richard Nixon live, broadcasting coast to coast and around the world on CRN Digital Talk Radio. That's crntalk.com. And Richard, I'm sorry I had to cut you off. We were going to break. Do you have a little bit more you want to talk about Marbury versus Madison?
Yes, thank you very much. I wanted to continue the quote by Chief Justice Marshall, who was the author of Marbury versus Madison, 1803, which basically says that the Supreme Court has the legitimate authority to overrule an act of Congress. And what I had said is that the powers of the legislature, now he's talking about the legislature, are defined and limited, and that those limits may not be mistaken or forgotten. The Constitution is written. So he basically says, if you want to know what the Constitution says or the powers that the legislature has, you go to the Constitution to look at those powers. Further, he says, to what purpose are powers limited, and to what purpose is that limitation committed to writing, if these limits may at any time be passed by those intended to be restrained? The distinction between a government with limited and unlimited powers is abolished if those limits do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. It is a proposition too plain to be contested. So right there, he's basically saying, if you want to know what the federal government's power is, you look to the Constitution so that you don't forget or mistake its powers. However, the most amazing thing of this in this case is that he went on to grant the Supreme Court powers that same Constitution did not grant him. That is, namely, that power for one of the three branches, namely the Supreme Court, to overrule the other two branches, in this case, Congress. And Thomas Jefferson was president at the time, 1803, and Thomas Jefferson railed against that and basically said, if that's the case, then the Constitution is nothing more than a piece of clay in the Supreme Court's hands to shape any way they want. And this can spring into tyranny.
Absolutely, absolutely. That's fascinating. So, I mean, you've spent a big portion of your career, and also a big part of your book. The main crux of your book is about federalism and the issue of states' rights, and this judicial overreach. Are there any cases recently in the news that our listeners might be aware of that discuss these issues? That it's
Yes, the recent case, I don't recall the name offhand, but it had to do with the legalizing of gambling, betting on sports. Essentially, the Supreme Court came down on the right side, but quite frankly, for the wrong reason. That is to say, the Supreme Court essentially said that by the Supreme Court finding that the federal law prohibiting sports betting in the states was equivalent to the Supreme Court or the Congress sitting down in the state legislatures and ordering the states to vote a certain way. And they came out with the right decision. However, the real reason for that is this, that where one is looking for power of the federal government, remember, it's all in the Constitution. There is no federal power is outside the Constitution. And to find out what Congress's power is, you simply go to Article 1, Section 8, 1 through 18, and you will see exactly what powers the Founding Fathers gave Congress. You'll see nothing about gambling, nothing about the federal government authorized to make any laws regarding gambling. Therefore, that's the position, that's the basis upon which that decision was correctly adjudicated. The idea that they simply didn't like what the states were doing is a right result for the wrong reason.
That's interesting. That's very fascinating. I'd like to bet on that, actually, maybe. Maybe lay some action
Right.
on that. So we've talked about the original sin of Marbury versus Madison when this judicial overreach really started, and it's still absolutely shocking to me that the the petitioners were relatives of the justice.
Yeah.
That is just absolutely insane. So how do we curtail this? I mean, what can we do? I mean, can Congress take back the reins? Can they take the power back from the judicial branch?
Well, absolutely. In fact, it's ironic that Article 3, Section 2, Paragraph 2, which you will never hear on TV, radio, or anyone, for some reason it's a secret that's very well protected. Anyway, Article 3, Section 2, Paragraph 2 basically says this, that the Supreme Court has appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress shall make. Now, what does that mean? That means that when Congress passes a law, they can cite Article 3, Section 2, Paragraph 2, and essentially tell the Supreme Court, all federal courts, frankly, you do not have jurisdiction to hear this matter. That is, we are withholding jurisdiction based upon Article 3, Section 2, Paragraph 2. Now, why did the Founding Fathers do that? Because, again, was supposed to be a country of the people, by the people, and for the people. And it was Congress's way of reining in the Supreme Court if they didn't want the Supreme Court to hear a matter. Now, why is that important? Because if Congress did cite Article 3, Section 2, Paragraph 2 to withhold jurisdiction from the Supreme Court, and Congress passed a Law A, let's say, that would make Congress immediately accountable to the people. They don't want that. They want plausible deniability. So they never, that is to say Congress never, I shouldn't say never, but almost never, has utilized Article 3, Section 2, Paragraph 2. They would rather that it goes to the Supreme Court, and then we blame the Supreme Court for the decision, like most people did when Justice Roberts seemed to turn coat and found Obamacare constitutional. Many people, including the media, were upset that he didn't go with the conservatives and find it unconstitutional.
So let me just, what I'm hearing, let me clarify for the audience, is that it's become a political tactic of the legislative branch and the executive branch to a matter where you can kind of kick that can down the road to the Supreme Court when they don't want to make the tough decisions that might be politically expensive for themselves. They rely on the Supreme Court to make that decision themselves because these justices have lifetime appointments.
Exactly, and that's why the name of Chapter 2 in my book is the conspiracy, the grandest conspiracy between Congress and the Supreme Court. Although they'll never say this explicitly, that's exactly what they're doing. They push the can down the road, and they avoid immediate accountability. Now, people will rail against Chief Justice Roberts for not finding it unconstitutional. That is Obamacare. However, he did exactly what was right. That is to say, he said, if you read between the lines, that it is not our job to correct your errors.
Fascinating. We'll be right back with more of this. This is an excellent conversation. Let us know what you think. 818-818-6401 and send those emails in. Richard Nixon at crntalk.com. We love those emails. We love to debate these issues because this is an important topic, guys. I think we all need to pay more attention to what's going on with the legislative branch and how they have usurped control of the other two branches. We'll be right back here. Richard Nixon live on crntalk.com. Richard Nixon live, crntalk.com. Welcome back to Richard Nixon Live, streaming live, crntalk.com. That's crntalk.com. And we've touched on a lot of important issues here, Richard. And, we talked about Marbury versus Madison as kind of being the original sin, but also a big crux of your book, America, An Illusion of Freedom, is the 14th Amendment and how important that is into this whole topic.
Yes, the 14th Amendment is unique in the Constitution because remember, the Constitution, its purpose was to create and limit the federal government. And again, we said earlier that the 10th Amendment was there also to limit the federal government. That is to say that powers that were not given to the federal government remain within the states. Now, there's one exception to the idea that the Constitution was intended to create and limit the federal government, and that is the 13th, 14th, and 15th Amendments, which were enacted after the Civil War, 1861, 63, and 65. But more specifically today, we'll talk about the 14th Amendment, which discusses citizenship, liberty, due process, and equal protection. Now, specifically, what I'd like to say is we've had recent cases, Roe versus Wade, which found the constitutional right to an abortion, and recently the Obergefell case, which found in the Constitution a constitutional right to gay marriage. I must say that neither one actually exists in the Constitution. And the question becomes then, how did the Supreme Court do this? How did they find these constitutional rights that no one up until then had found? And it's because they looked at the 14th Amendment Due Process Clause, which basically says, no state shall deny a person of life, liberty, or property without due process. And they took the word liberty, which, by the way, Justice Thomas in dissent researched back to the 1200s and said liberty has always meant one thing: freedom from confinement. That is, that you're not jailed, you're not incarcerated, you're not locked up, essentially. So there's been no question as to what the word liberty meant in the 14th Amendment in that context. However, in recent years, a federal judge in Massachusetts found that the word liberty really meant freedom to marry someone of the same sex. Again, that's totally made up. It's total fiction. And the reason that the Supreme Court was able to do it is to simply redefine terms. And that's what they've done. They redefined the term liberty in the 14th Amendment to find a constitutional right to an abortion and a constitutional right to gay marriage. Neither one actually exists in the Constitution.
So they've extrapolated a different meaning for the word liberty when, liberty, as you said, is a concept from English common law, where it just, like you said, it means confinement. Liberty means not being locked up in gaol, as they called it back then. But now liberty can mean anything. It can mean anything to anybody.
Well, that's right. And you see, that's in total contradiction to what we had said earlier, where the role of a judicial officer is to effectuate the intention of the legislature, and that is the legislature, which theoretically reflects the will of the people. So there is So this is an absolute contradiction to everything that all attorneys and justices learn. That is, a judge's role is passive. You're supposed to do what the people want done through the legislature and the laws. And by not doing that, they're in clear violation of the Constitution itself. And technically, Jefferson, back 200 years ago, as a result of the Marbury versus Madison case, said that he was president at the time, and he said the solution for that is to impeach all of them.
Wow, that'll do the job, I would say. That's amazing. Yeah, the 14th Amendment, I think, like you said, it was designed shortly after the Civil War to re-enfranchise former slaves. It codified in law that they were citizens, birthright citizens. They had all the rights of the rest of the citizens in the United States. And then to see that, which kind of makes me a little angry, because that's such an important historic amendment, in the ashes of the Civil War, to free a people, and to now use that language to really make any argument you want, be it gay marriage, be it service animals on airplanes, anything you want. That just doesn't seem like the spirit of the law.
Well, that's right. And you see, what upsets me, and hopefully will upset the audience, is the Constitution is our main law. It is the supreme law of the land. I don't question that. And so if something's in the Constitution, then we are bound by that. And the vehicle by which, if we don't like what's in the Constitution, is Article 5, an amendment process, which we've done some 27 times in our history. And in Article 5 of the Constitution, the only people involved in that amendment process is the state and federal legislatures. There's no mention of a president or the president or the judiciary in Article 5. Therefore, what upsets me the most is if the Supreme Court finds something in the Constitution that is legitimately in the Constitution, we're bound by it. What upsets me, again, what I'm trying to say is, where they find something in the Constitution that is not there, they have simply taken that issue from the people and given it to themselves with no legitimate authority. The people should be upset that thereby those issues are taken away from the people, given to the given to the Supreme Court by the Supreme Court.
That's fascinating. Yeah, I'd much rather be represented by more than 9 justices on the Supreme Court. It's absolutely amazing. We are here, Richard Nixon, live, broadcasting on CRNTalk.com. We'll be right back to wrap things up here. A lot more good stuff coming up, though, so make sure to stay with us through the break. And we want to hear your opinion about this, you guys. Any attorneys out there, any laymen out there that want to discuss these issues, shoot us an email at richardnixon@crntalk.com. That's richardnixon@crntalk.com. We'll be right back with more of The Richard Nixon Show, Richard Nixon Live on CRNTalk.com. And we are back. Richard Nixon Live here, streaming live across the country and around the globe on CRNTalk.com. That's CRNTalk.com. And Richard, we were talking during the break. It doesn't really matter whether or not you agree about certain issues, be it gay marriage, be it abortion, be it gun control. It really matters on the process, on whether or not this is actually legal. I mean, you can be for or against any of these issues, but if you don't respect the Constitution and what allows these laws to be passed, it doesn't matter, right?
No, that's exactly right. In fact, we had mentioned earlier the fact that when the Supreme Court redefined the term liberty in the 14th Amendment, this is the vehicle by which they found, let's say, the constitutional right to an abortion, a constitutional right to gay marriage, or same-sex marriage. That's how they were able to find it in the Constitution. And I want to be careful to mention that I take no position on either one of those issues. My position vis-a-vis those two issues is those issues, when the Supreme Court found those things in the Constitution, they basically foreclosed that issue from the people. That, again, that's what I resent. The people should have been free to make those decisions regarding abortion and regarding same-sex marriage. But by finding something in the Constitution that did not exist there, they literally took that issue from the people. And again, if we believe that this is a country of the people, by the people, and for the people, and that was the main purpose of the Founding Fathers creating this country, it is clearly a usurpation of the freedom of the people when the court takes those freedoms from us.
So, Richard, I mean, you've been a practicing attorney for over 40 years. You've done quite well for yourself. Why do you want to come here and do this radio show?
Well, again, it's because this country, and again, I have to remember that I am not anti-America or anti-country. I am simply anti-federal government where it exceeds its express constitutional authority. And the reason why I feel that I must give back to this country is for that precise reason, that this country has been good to me and the legal profession. And since I found out through my research that, in fact, the people are unaware of what our government has done, specifically the Supreme Court, by quietly and slowly and stealthily taking our freedoms from us one at a time. It's mindful of that frog that doesn't realize he's being boiled because he's put in cold water first. It's the idea that just in one little niche at a time, the Supreme Court is basically taking our freedoms from us. And I felt an obligation to pay back and let the people know what I found out.
We just got about a minute left real fast. And so I want to thank you, sir, for doing this show. And I mean, it's just so generous. Not only did you served our country, and now you're serving our audience by giving these constitutional lessons. We got about a minute and a half left. I know you want to read something from the Bill of Rights that is close to your heart.
Yes. Well, it's important for the people to realize that I'm not being a heretic here or unfaithful to this country. I'm simply demanding, if you will, that the people who run this country, that is our government, abide by the Constitution and recognize that this country belongs to the people, not to the government. And I want to read something from the Bill of Rights, from the Declaration of Independence, which predated the Bill of Rights. And it basically says, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. And this is the important part, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it. Now, my point is this. I don't want anyone to be backward or embarrassed that we are taking a stand against our own government.
Absolutely. Thank you so much, Mr. Nixon, for coming in. This is Richard Nixon Live. We're here every Saturday, 1 p.m. Pacific time, 4 p.m. Eastern time with more. We'll be back next week, you guys. More with Richard Nixon Live on CRN at Digital Talk Radio. Thank you so much once again, Mr. Nixon. We'll see you guys next week.